This way.
I know. She's only up here from North Carolina.
That's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay, and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now.
What is what one do you have?
And this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva.
There's two items checkmarked here.
This is after the fact. So then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me.
Before we even press play, let me set the stage for you. What you're about to witness is not just a courtroom appearance. It's a full-blown ideological collision. On one side, you've got a district court judge trying to conduct a routine contempt arraignment. On the other, a self-declared living soul who rejects the court's authority, denies jurisdiction, and leans hard into sovereign citizen talking points. Now here's where it gets wild. This isn't just someone confused about procedure. This is someone who allegedly cut up a court order, wrote, offer to contract not accepted, in red ink, and then refused to appear. And now she's standing in front of the same judge explaining why none of this applies to her. But here's the real tension. The judge is calm, methodical, giving her every opportunity to understand her rights. And she's interrupting, challenging, refusing to directly answer the simplest procedural questions. This is where things usually go one of two ways. Either the judge shuts it down quickly, or the defendant spirals deeper into confrontation. So the question is, will the court maintain control?
I probably have more degrees than you do.
Wait, is she seriously flexing more degrees right now? Like, are we talking about Sovereign Citizen University? Or is this just the McDonald's training video she watched in 2012? Either way, this girl's got the IQ of a lukewarm bowl of soup, and she's literally out here acting like she's ready for a legal showdown. Meanwhile, her lawyer here is just trying to make sure she doesn't get obliterated like a cheap folding chair in a WWE match next time she steps into the courtroom.
All right.
Okay.
All right.
Now,
I'm going to find that.
Please, Judge Gothier.
Sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original show.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would you like to see what she has here?
I just,
Okay,
you don't
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing to show
But I wasn't on bond. So both show causes are not in effect because I'm not.
22222222222222222. Right out of the gate, we're hearing classic sovereign citizen terminology: special appearance, living soul, strawman, all caps. These phrases aren't random. They're part of a belief system that claims the government creates a separate legal entity, usually represented in capital letters, and that you can somehow separate yourself from it to avoid jurisdiction. The problem? Courts across the country have rejected this argument over and over again. Judges are trained to move past it quickly because legally, it has no standing. But notice something important here. The judge doesn't snap. He doesn't escalate. He calmly says, "We'll get to that." That restraint matters. Now here's the tension building. She believes she's asserting rights. The court believes she's evading procedure. And when those two realities collide, things usually don't end quietly.
First show cause.
December 20th.
No, the December.
Sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then
So-
send it back.
Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do.
Okay.
That is a hearing date. Today, we're going to schedule a hearing date, and you can present that evidence at that time.
And how will the hearing affect a trial by jury
As I told you, there is no right to trial by jury
for
in
a contempt charge?
So I can
So
schedule
this is a perfect, nice little tidy package for everything. I see.
She's eyeing those papers like she's about to rip them up and start doodling with her favorite red crayon again. At this point, every court doc is just another page in her personal coloring book.
Okay.
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that, state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th. Then that gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long
No.
as I'm convinced that you're doing so of your own free
Okay.
choice, that you understand what's going on and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath,
Okay.
yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
If
I
you want
can't
to
subpoena
subpoena
them.
somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena. They would give it to me to review. And if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant, but everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out today.
Well, that's a lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to,
Mr. Richmond,
okay, I get it,
You're not
Judge
fooling-
Gothier, I know what happened,
You're
but
not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
yeah, but I brought it at 9:00 because do you know that that's actually a common law practice?
I just have a feeling this Karen sovereign citizen is in her head like, oh, I get
Because this is crucial. The judge just laid out two specific contempt allegations. First, unauthorized practice of law. Second, interfering with a defendant meeting their appointed counsel. And then the big one, failure to appear after allegedly submitting a cut-up show cause order. Contempt of court isn't symbolic. It's not theoretical. It's a direct challenge to the authority of the court. And when a judge signs a warrant for failure to appear, that's serious. Notice how structured and procedural the judge is being. He's outlining rights, penalties, options for counsel. This is textbook due process. Meanwhile, she's still focused on jurisdiction theories instead of addressing the factual issue. Did you show up? Did you interfere? Did you comply? This is where reality and ideology start separating fast.
unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Bridgman's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of that's a question of law that you can research before that day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training and researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney, or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to.
No, I've been down that path before, and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yeah, Ms. Bridgman, if you want to represent yourself, it's a little bit more work. You're going to have to
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with, or that anybody has any proof of what they said here. So that's what okay.
All right. Well, that's what we'll.
All right.
Those
Thank you.
Arguments, and the prosecutor will present witnesses at that hearing, and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf,
okay,
submit a subpoena to the clerk's office that I would review. It'd be the district court office.
Okay.
That I would review, and I would issue the subpoena.
So one of the key laws would be that in the state of Michigan, anybody practicing law should have be a member of the Bar Association. Am I correct?
That is correct.
Yeah. Now,
Ma'am, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have a range of
I get it, but I
Right.
appreciate that this is very big in scope, and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay,
That's not symbolic. That's real confinement. And the judge clearly explains it, up to 93 days and or a $7,500 fine. Now watch the dynamic here. Instead of acknowledging the risk, she pivots back to procedural technicalities about service and bond status. That's a risky strategy, because contempt hearings don't hinge on philosophical debates. They hinge on compliance. And here's something viewers should think about. When you're facing potential jail time, is this the moment to argue theory, or the moment to secure counsel and focus on defense? Because the judge is laying the foundation. He's documenting that she understands the penalties. And once that record is clean, the court can move forward whether she agrees or not.
Any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
so the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
She's not going to come testify, I'm sure. She's downstate. She might write something.
Well, that's up to you what you want to present. If you're going to represent yourself, you have to decide how you want to present your case. But I've given you the extra time you've asked for.
So this is a major judicial review, okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights.
And most of what I talked about actually falls under common law because it's common that anyone could understand it.
All right.
That's
so
why it's called common.
You set the hearing date.
Okay.
We'll arraign you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance or whether you should be required to post a bond before the next hearing. All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether...
I showed up at 9 a.m., Your Honor, and anybody could have called me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the...
She claims a state trooper told her the show cause couldn't be issued because she wasn't under bond. That's her justification for not appearing. But here's the issue: verbal advice from an officer doesn't override a signed court order. Only the issuing judge can modify or withdraw that order. So even if she genuinely believed she didn't have to appear, the court's perspective will likely be simple: you had a written order. You didn't show. Intent might matter at the hearing. But at this stage, the judge is focused on one thing. Does she understand the charges and her rights?
Question here, I think. And I think a lot of people
Well, I can
struggle with
recommend a
that.
Schoolhouse Rock video to you about how a bill becomes law, and the laws.
Oh, I know how it happens.
Your Honor,
I also know we don't have a lot of
Your Honor.
judicial review.
So
Your Honor, part
as the
of the-
bond question, any input, Mr. Villanueva?
Yes, I guess I know you just released me as the attorney of record, but I guess in support of the bond on her behalf.
Yes, go ahead.
Yeah, so I like to advise the court that